Welcome everybody back to our webinar on documentation. Today we're going to talk about documentation habits, some rules around that, and some stories around that, and the form of examples of what to do and not to do. And we're going to try to explain how companies can better, well, individuals first, but then companies better have control over what's creative, or more how it's creative and what the content of documents are or is, excuse me. Um, I'm David Graham. I'm from Gardner Law. I litigated many medical device um, cases and drug cases. And so most of my stories come from either medical device and drug cases, False Claims Act cases, or food class action cases. Um, so the agenda today is a recap of what we did last week. Then we'll do an introduction to the rules of the road. That should just be the rules of the road, probably. Talk about bad document creation practices, good practices, some organizational avenues for reporting, and other ideas around corporate culture and integrity that can help with people's uh, habits around document creation. And then if you have questions, please ask them, and I will try to take them from the question box in the webinar. So the first thing I want to do is recap before we go on to the subject matter for today, is kind of recap what we talked about last time, and that is we went through sort of the structure in which documents fit in a litigation, and that was privacy, confidentiality, the rules around spoliation, and that is the proper retention and destruction of documents. We didn't go into details of any of those things, but talked about having an awareness of and a plan for those things. And one I left out, mea culpa, is privacy, which is obviously important because you might probably would have patient information. Even back before HIPAA and other things like that, we had to pay attention to people's personal information. There should be, in all medical device or healthcare companies, drug companies, there should be already structures in place and rules in place within the company to protect the privacy of patients' documents and other people's documents. It might even be the privacy of employees, depending on the circumstances that may be witnesses in litigation. You can't, just because somebody knows information about a particular liability issue or a fraud issue or something like that, doesn't mean their personal information is up for grabs. So remember privacy when you're thinking about document retention and document policies. And I'm sure most of the companies, or most of you listening, are well aware of the rules around that, both in the United States and Europe and other places. Paul in our law firm is a privacy expert. So if you ever have questions about that, you can talk to him. And we have plenty of people that can give you advice about that. And you may also have those within your organizations who you can talk to. So if there's ever an issue about passing on private information, that's important to keep in mind. So today we're going to talk about sort of the rules of the road and just how to avoid making bad documents. And in my mind, this comes down to sort of culture issues, habits, and discipline. So you need to view creation of documents as conduct, not just I'm writing something down and recording it. In other words, when you get to trial, the attorneys are going to make whatever you have in documents sound like the attitude or the values of the firm that they're trying a case against. So the writing is just not a a recording again. It's something that reflects what the company thinks and has done. So as you remember, as we talked about last time, a lot of it comes down to intent. Obviously, when we were talking about spoliation, intent was the thing, but it's also intent matters in cases. It can be the difference between a civil case and a criminal case. It can be the difference in how much a jury evaluates a company's level of negligence. And so intent is important, and intent can be reflected in documents in certain ways. So inartful documents, even though they weren't meant to be malicious or in any way a reflection on the person's view of the company's values, they can be read that way. So you got to think of document creation as not just recording, but conduct. And I want to remind you of this as well. When we're talking about lawsuits, oftentimes, especially with liability related to personal injury, but also with fraud cases, prosecutors and people trying to win cases against your company want to know, what did you know? That is, when did you know it? And what did you do about it? So documents go into that general architecture of a case. It seems really simple, but if you've ever sat through a deposition, and I hope you have not, but if you have, you'll know that's what they want. That's what they'll ask you about. They'll go through your documents and want to know, they'll want to create a timeline. They may have created a timeline already when they've gotten to you. And so they're going to put your documents into this timeline and try to determine what you knew and when did you know it and what did you do about it. So you got to keep that in mind when you're creating documents. Maybe not documents where you're just sending invoices to people who pay it in the firm. Maybe not documents that are just setting up meetings. But when you're especially when you're dealing with, potential recalls, complaints from consumers, maybe internal complaints, maybe FDA inspections or the aftermath of an FDA inspection where you're dealing with 483s and things like that and making a strategy around what to do with it. Or marketing, especially marketing. You need to put a little more thought into how the documents are created and how they reflect them on the company's values and what they want to project as those values to the medical community and to the public. Most companies in medical device and healthcare and food companies are set up to do good things for people. They're set up to heal them, feed them, and give therapy in some way. People aren't creating new technology, not only for profit, it actually hopefully lowers the cost of care and makes people get better faster. So a lot of times what happens in our daily business is our writing, which will be interpreted as conduct and a reflection on our values, gets to be so in the moment that we don't remember. It's not that we don't care. That's not my point, is that we kind of lose sight of the general mission of the company. That's enough of that sermon. I'll get on to the rules of the road. First is nothing's in a vacuum and you're not alone. You can write a memo to somebody or an email. Why do I say memo? I'm sorry, an email or text, and it's within the context of your employment at a company. Sometimes I think when I read documents from people and back and forth amongst employees, and it ventures not just a little outside the business goals of the company or the business purpose for which things should be written, it gets stilted. And again, this is nobody's trying to do things malicious, but you got to remember you're operating in a team context, and what you write is what the company writes. Maybe that's the better way to say it, more concisely. So even though you might not technically under the law be a representative of the company and may not be able to bind the company because you don't have the appropriate authority, it's still the company speaking. It's going to be read to juries as if the company is speaking, even though you're a person who may not have that legal authority. So when you write to achieve a business goal or advance the business and determine what you are intending to say. And if what I am saying is consistent with getting a job done for the company and completing whatever assignment I have, then that's what you should be writing. If it doesn't seem like that, it's more than that, and you're not sure about it, and it may be because of the unfamiliar or the task you've been given is unclear, but you need to clarify that. Doesn't mean you have to sit and think for 10 minutes about everything you write. Business moves fast, especially for developing companies trying to develop new products, get them approved, dealing with a budget from investors and things like that. But cutting the noise by just writing, advancing the business purposes of the company is one simple way to keep documentation under control, at least ones that might be viewed as outside the bounds of the business. Assume that someone that is not intended recipient of the communication will read it. That is, you need to write, even if the addressees are 3 specific people on a specific project, and you've been working with that group on a project, you need to assume that other people in the company are going to read it. Obviously, you probably have reporting to do. It might be investors. Things you write might be incorporated into offering documents or other documents like that. Certainly regulators might view the documents depending on what the purposes of them. And so you need to assume that even though your audience seems limited in the moment, it's not going to be. It's a company document, and therefore it won't be something that you can keep control of. Especially if litigation occurs, it's going to have to be produced to another group of lawyers on the other side of the case, and will be interpreted however they interpret them. So, and that interpretation might be being done by a person that's a recipient of the document who's now not a friend of the company. So it's important just to assume that it's a document available to the world, and assume the document will be evidence in a legal proceeding. I try to get people to just pretend like it'll be read to a judge, right? So if you read your document, your email or whatever, and it wouldn't be appropriate to read in open court or before a jury or a judge, then you better rewrite it, or at least think about it, or go talk to somebody about it. So it's important to keep in mind that it takes on a life of its own once it goes into the cloud or wherever it's stored, and it gets produced in litigation. All the context, you lose the context, possibly is a better way to put it. So terms that are not carefully chosen, or other allusions to things that might seem funny or sarcastic, or things that within the group you're communicating with seem perfectly fine, might not be. Businesses don't need to be humorless, but the humor might be better verbally than in writing. So you just have to be careful about that because of the reflection it might have on your company through the interpretation of somebody who doesn't have good thoughts about you. So, excuse me. So that's the 4th rule. The final one is probably the most obvious and maybe the most important, but gets forgotten a lot. So we're trying to build things economically, products or drugs, and we want to do it in the safest possible way. This applies to food too, and I'll give you an example where it comes into play. And we're talking about processes, manufacturing process, good manufacturing processes, and the regulatory requirements around them, And obviously the most efficient way to do it to keep the cost of our products at its lowest, but also have a very safe product. So one thing you don't want to ever do is say, we didn't employ these safety processes because they were prohibitive monetarily. Don't do that, right? There's always give and take, right? First of all, you got to remember that nothing can probably be made in most situations 100% safe, right? So think about it like that. So when I'm writing a document about safety and I'm talking about the cost of that safety, it's not that there's not a ledger somewhere where the company keeps track of the cost of processes and um, uh, and what that means to the cost of the product, but there's a sliding scale one that within reason makes sense. But you got to be careful how you talk about it. There was a long time ago now, it's hard to believe, there was the Peanut Corporation case where peanuts were contaminated. And then of course the peanuts are sent off to make peanut butter and that gets contaminated. Well, what sunk the executives of the company of the Peanut Corporation, which it was called in Atlanta, Georgia, is that they said, well, we can't afford to change or clean our machines or afford to address this in the way we need to because of the cost, because they'd have to recall product and things like that. Well, doing that immediately impugns your integrity, and probably should have in this case. And even though you might mean in a memo that making it 100% safe would triple the cost of the product, you can't talk in those terms necessarily, right? Everybody knows, and it's our job as lawyers, as trial lawyers, to explain to juries, the relative cost of safety, and that all products have, especially medical devices and drugs, depend on many, many, many things for its ultimate efficacy and safety. Could be the patient, especially with medicine, well, not all, but many, many medicines, including still antibiotics, kill people. That's just, everybody's different, and it depends on that. Depends on the people using the product, that is the surgeons, not to impugn providers at all, but everybody has different skill. There's different circumstances in which products are used. So that is even beyond what happened at the manufacturing level. So when we're trying to tell the company's story, if we have a document, so we're trying to get people to understand relative risk. And this is important. So when you're explaining to a jury risk, right, you're comparing it to driving, which is almost always more dangerous than most medicines or devices. And you're trying to explain all the clinical trials and all the things the company does to make sure a product is safe, all the regulations it follows, all the things a company may go beyond the regulations to make a product safe, especially in food safety. Regulations are sort of where you start, and then you have to, probably go well beyond that to truly have a safe place to produce food. And it's also true with clean rooms and other ways that healthcare products are produced. So you're trying to get the jury to appreciate the relative risk of things, and that medical devices are generally pretty safe. But if you get a couple of memos where people are saying, well, we can't do that because it costs too much, and it's not put into proper context and it's not explained correctly, then it makes the hill a lot higher to climb when defending the product and telling the company's story, which is almost always one of a tremendous care. And at least in my experience, I've always been very proud to be able to stand up for companies that make medical device products, even food products. Doesn't mean everything goes perfectly all the time, but generally the intent is that we took all reasonable safety precautions despite cost to make our product safe. And also, you're also trying to explain to people the cost of it not being. It's so prohibitive and it puts you out of business so fast that obviously most expenses are tolerated in developing the product. I just want to make sure I'm keeping track of questions here. If you have any, ask them on the way and I'll try to pick them up. But I will proceed. So what are bad document creation practices? Some of them are very obvious, but some of them sometimes are something that we can implement in our daily practice of communication. You know, we communicate a lot more than we used to, if that makes sense, right? I mean, before you email, you had to get up and go talk to somebody or write a memo. I mean, actual memo and not just an email. And you had to, or go talk to, or pick up the phone, right? So in any event, it's, and I'm sure lots of companies talk about this with their employees, but we're gonna talk about these rules, plus it leaves some room for some interesting stories that have occurred, most of them unpleasant when I face the documents in the context of a litigation, but in any event, it is what it is. So as I may have told you with this first, the jailhouse memo I was reviewing, I was in a warehouse of 1 million documents for a medical device company. And I ran across a document with a person with sticking their head between bars. It's just handwritten, hand drawn, you know, picture of a person looking through bars. And it said something like, this is where we're all going to end up. And that was that person's attempt at humor about what that person thought of the company's context vis-a-vis this certain process within the development and sale of this medical device. And you couldn't have a more pejorative memo, right? And it's just a classic example of a person either making fun of something that shouldn't be made fun of, and that is patient safety, or actually serious, right? And thinks that there's criminal conduct going on. And most conduct in product liability cases and even False Claims Act cases do not raise to the level of a crime. They can, but generally it doesn't help though. I mean, what does it make the company's intent look like? If you employees, you know, you'll get that employee and you'll depose him. Why'd you draw a jailhouse? You know, and they'll try to pass it off as, well, I was just goofing off, right? But usually something prompts it. And this was in the context of a quality control step that they didn't think was appropriate, or was not. That's wrong. It wasn't that they didn't think it was appropriate. They didn't think it was there at all. So that's doesn't help. So it can raise the stakes fast from something that is already probably a very expensive product liability or fraud case or patent case, but usually with those kinds of things, it relates to the former two, and how that can impact people's perceptions of the company. So the next one's the hangman noose memo. This was in a different litigation. This had to do again with a medical device, and somebody was talking about regulators coming in to do an inspection. And it wasn't, there wasn't, before finding this memo, there wasn't a particular concern about, by the defense, that means our team and the company, about, boy, we don't think we're just completely frivolous when it comes to what the regulators will care about in terms of good manufacturing processes, documentation, clean rooms, all the things that go into an inspection. And of course, then we run into the hangman's noose memo, which is a person drawn with a hangman's noose around his neck, like they're hanging. And it just, again, you completely paints, right? Of course, we have to go find the person. The person was not a manager, was a person who had just started out as being a quality control person and just, right, didn't use judgment but was upset about what was going on in terms of the quality control process, although they had walked into the middle of it when it was being developed and there were unanswered questions. So instead of asking questions, there's a document about, well, we should be doing this, and there's a hangman's noose was supposed to represent, on questioning later, patients being injured, right? So not very helpful, extreme, as a matter of fact. And then, so don't do that. The next one is a document that I had in a False Claims Act case. And in this case, it was a question of implementation of the compliance plan. So we were defending a case regarding, obviously, what the company or the healthcare company was doing in terms of compliance, and it was doing mostly good things. But this particular employee, excuse me, didn't think we were. And because of her view about a particular issue, it had to do with monitoring, and it wasn't perfect, but it was being addressed. Even long before somebody blew the whistle, long before that, was addressing it, but wrote this, if we don't correct this compliance and start plan and start monitoring it more closely, we'll have this will be a disaster of epic proportions. And of course, it's not good. I mean, her opinion's important, right? Nobody thinks that it wasn't important, but the characterization was way beyond what was happening in the context, and the person didn't understand that it was being addressed. In other words, the company was in the process of dealing with clearly a stale compliance plan that needed to be updated and monitored more often, and we're in the process of doing that. So instead of, again, writing this, instead of going, hey, you know what, I have a little concern about, when's the last time we actually looked at what the performance of this plan is and things like that. So, instead of asking that question and then finding out that, oh yeah, you're right, we need to update it, we need to monitor it, and we're in the process of doing that. You can help us with that by doing this. This gets written. So then of course, nobody knows about it or says anything about it until then there's a case to be dealt, a lawsuit to be dealt with because a whistleblower came forth. And so now you got this, she has to explain it. It's very uncomfortable for the witness, right? So the witness goes, it gets grilled by the prosecutor. And then, what were your concerns? And you were concerned enough to write this, weren't you? So it must have been you must have really thought that this was a problem for the company, right? Well, yeah, I did. And then we have to go back, and when we get to ask questions of the witness, we have to go back and do the rehab, right? And we have to say, well, but you didn't know that that the company was in fact working on this issue, and you later found out. As a matter of fact, you found out whatever the timing was, 2 weeks later, when that in fact there was a team working on this, and you just hadn't got incorporated into that process. So you have to do that, and it can help, but it's never as good as not having to deal with the matter at all. So that